Section 111. Circulation of the members' resolution. Mark the triple ones. Circulation of the members' resolution. Sir, what does this section have to offer? Let's check it out. First, notice to the members. This section says a company shall, on requisition in writing, means somebody is going to make a request to the company and that request is coming in writing. On requisition in writing of such number of members as required under section 100. Sir, 100 extraordinary general meeting. Do you remember? So such a number of members that we have studied under section 100, minimum that many number of members shall be required to make an application to the company in writing. But sir, at least tell me, what application are you talking about? Which application are we talking? Which application? That's a good question. Well, we are saying that the application is about giving a notice to the members of any resolution. Of any resolution which is intended to be moved at the general meeting along with explanatory statement. So if at all any member, any group of members, how many members, sir? As we have done under section 100, correct? Sir, we will, I know you don't remember, right? Let me show it to you. Yes. Can you see this? Company having share capital, 1/10 of the total paid up share capital. Not having share capital, voting power. Correct? Yes. So these many number of members shall be required in order to make an application under section 111. If these number of members make an application under section 111, then the company will forward a copy of that application along with the explanatory statements to all the members of the company. Now, what is it about? Pay attention. Exemptions from serving the notice. A company shall not be bound under this section to give the notice of any resolution or circulate any statement unless a copy of the resolution signed by the people who are making the requisition, that is the requisitionists, has been deposited at the registered office of the company as follows. So what they are saying, first of all, before you order the company, just because you are 1/10, you cannot pass orders on the company. Before you make an order to the company, that company, we as members want you as a company to send a notice to the members for passing a resolution. You don't give orders to the company because you need to first confirm with the company whether whatever notice you are proposing, whatever resolution you want to pass at the meeting, does it require a separate notice or not? So here they are saying, in case the resolution requiring the notice of a notice to be passed not less than 6 weeks before the meeting. So if that type of a resolution, whatever you want to pass, it requires a notice. It requires a notice to be given to the members. You have to inform the company about that 6 weeks before the general meeting minimum. And in any other case, any other requisition where notice is not required to be given in advance to the members, minimum 2 weeks before the meeting, you should inform the company. Clear? So you need to understand, holding 10% or more, you cannot pass any order that you want on the company now. If you want the company to pass any resolution for you, for which the company has to give a notice to the members in advance, your responsibility to give a copy of that resolution with explanatory statement to the company 6 weeks minimum before the meeting. And in any other case where informing the shareholders in advance may not be compulsorily required, then 2 weeks before the meeting you have to inform. Clear? First thing. Then they are saying company will pass this resolution. Okay, company will pass this resolution if you have proposed, but for passing that resolution, if notice is required to be given to all the members, why should the company bear that cost of sending a notice? Sorry, boss. A sum which is reasonably sufficient to meet the expenses of the company shall be deposited with the company, that is by those people. So if you are making a requisition to the company and requiring the company to send a notice to all the members, you must also deposit a certain amount with the company. You must also deposit a certain amount with the company so that the company can easily make distribution of that notice to everybody. AGM is called on a date within 6 months after the copy has been registered with the company. That is minimum requirement. So when you deliver the copy and if notice is required to be given to the members, AGM is called minimum 6 weeks after that. Exceptions from circulating. What are the cases where the company will not be required to circulate your copy of the resolution required to be passed at the general meeting by the form of a notice to all the members? The company shall not be bound if on the application either of the company or any other person who claims to be aggrieved, there the central government by order declares that the rights conferred, meaning transferred, are being abused to secure needless publicity for defamatory. If the central government feels that whatever application you have given for passing of a resolution, it's just a stupid publicity stunt. It's just a nonsensical publicity stunt where you are trying to defame the company or maybe trying to gain some publicity for yourself, cheap publicity for yourself. You are abusing your right. The law has given you the right that if you want to pass any resolution, you can, if you are minimum 1/10, you can inform the company about the same with a copy of the resolution, and company will forward it to all the members. But if you are doing it only for the purpose of gaining some publicity, if you are doing it only for the purpose of abusing your rights by spoiling somebody's name or goodwill for no valid reason, your application can be rejected also. The company will not be bound to circulate any such statement also. The order made may also direct that the cost incurred by the company shall be paid to the company by the requisitionist. So whatever order is being made over here, whatever expenses are incurred by the company, you will have to bear those expenses, failure for which you will be liable for a penalty. If default is made in complying with the provisions of the section, company and every officer will liable to a penalty of rupees 25,000 flat. Rupees 25,000. That is a new penalty, guys. Yes, that is a new penalty. That is an amended penalty, and that is applicable for you, and you have to go through it. Clear? I hope you have understood the section very well. I am leaving the section on your screen. Mark this section as important for your exam. Leave you with it for a couple minutes. Go through it, read it, note it, mark it, and then we will go on to the next section. Thank you very much. God bless. Done? All right.